So good afternoon. Thanks everyone for joining our webinar today. We still have a few people logging in, but we have a lot to go over, so we'll go ahead and get started. Typically we schedule these webinars months in advance. However, from time to time, things happen, stuff happens, and there's major changes in the legal landscape that require us to act quickly and provide guidance to our membership. Obviously, the reason we are here today is because we are in the middle of one of those changes. The open carry law in Florida changed, and starting September 25th, we started receiving lots of questions and inquiries from our membership regarding how this impacts their operation, questions regarding their workplace policies and overall public safety considerations, right? From a risk management perspective and insurance perspective, our goal is to understand the liability exposures associated with these changes, and to be in a position to provide the guidance and educate our members and provide the resources to help them understand and mitigate these exposures to the extent that we can, right? So I see a lot of familiar names, but I'll go ahead and I should introduce myself first. My name is Andy Jimenez. I am the Executive Vice President of Risk and Trust Operations for Aegis Insurance and Risk Advisors. We serve as the program administrators for the Florida Insurance Alliance, that's FIA. FIA is a governmental insurance trust, and we provide property and casualty insurance to a little over 1,300 local governmental entities and schools, and that includes 900 special districts. Speaking of special districts, I do want to just thank briefly the Florida Association of Special Districts. I know that their members are joining our webinar today. I encourage those board members, district managers that may not be familiar with FASD to check out their website, fasd.com, learn about what FASD does for special districts, some of the benefits that come with being a member of FASD, and also encourage you to attend their quarterly meetings at their annual conference. Right. Their next meeting is the Legislative Forum in Tallahassee, one of the best meetings in my opinion, and that is on January 14th. Right. To help us navigate today's topic, we did partner up with a panel counsel, the law firm of Roper, Townsend, and Sutphen. I've had the privilege of working with Cindy and Mike and the rest of the team for close to 10 years. They've been working with our members and representing and defending FIA members for even longer than that. They've been around for over close to 30 years. They specialize in governmental entity defense. What I like about working with them is that they can do anything from labor law all the way to general liability, auto, and my personal favorite, public officials liability. So when it came to discussing how we're going to approach this topic, I knew that Cindy Townsend was the perfect person to kind of lead today's discussion. So we'll go ahead and get started. I'll be monitoring the Q&A. Cindy, thank you for putting this together. We have a lot to go over, so the floor is yours.
Okay, great. Thank you so much, Andy, and good morning to everyone, and thank you for attending today's webinar. And hopefully we'll be able to cover a lot of the questions that you may have been thinking about since this new law went into effect. So first of all, I know that you've all heard about the ruling that came out from the first DCA regarding the McDaniels versus state decision that was made on September 10th of 2025. And essentially what that case did was overturn Florida's open carry ban law. And as a result of that, there has been lots of questions as to what does this mean, what happened in that case, and how is it going to have an impact on your daily operations and dealings with members of the public, as well as others. To the next one. Okay, so here's what happened in McDaniels to give you some background on how this case came up on appeal and has had such a monumental effect on everyone in Florida. It happened several years ago. McDaniels was basically, I think, testing the constitutionality of his right to bear arms openly. So he chose a major intersection in downtown Pensacola. He held up a copy of the U.S. Constitution and he was waving at vehicles. In addition, he was open carrying a handgun, which was loaded. It was in a holster, but it was visible to basically anyone who went by. As a result, law enforcement was notified. They appeared and approached him. And while he did have a valid concealed carry permit, he was advised by law enforcement that, while that is lawful, you cannot open carry, and that is against the law. They took away his firearm, they gave him back his holster, and then they went and later obtained a warrant for his arrest. McDaniels got wind of the fact that they were coming to arrest him, and he decided to turn himself in about 1 week later. He was charged with violating the open carry statute, which is 790.053, and that's a criminal statute. Prior to the criminal trial, McDaniels moved to try and get the charges dismissed and to have the open carry ban law declared unconstitutional. And he only did so under the Second Amendment to the United States Constitution. There was no mention or reference to the Florida Constitution. And again, we found that to be very strategic because as a result of his appeal. So after his motion was denied by the trial court, it was as a question of public importance to the First District Court of Appeal. And that is what then rendered the decision that came down in September. All right, so what's also important to note in the appeal was that the state of Florida, which would have been led by the Florida Attorney General, they did not dispute that the open carry ban that was protected. And the Second Amendment specifically says that as a citizen, you have the right to keep and bear arms. And there is a seminal case that addresses a U.S. Supreme Court case, the New York State Rifle and Pistol Association case versus Bruin, relied on by the First District in interpreting whether or not constitutional. So the first definition of what does bear arms means, and they determined that extends clothing or in a pocket. After the first DC extensively did an analysis of the constitutionality, decided that Florida's open ban on weapons was unconstitutional. And accordingly, the criminal statute under which McDaniels had been prosecuted was now declared to be unconstitutional and inconsistent with the nation's historic tradition of firearm regulation. As Andy mentioned, this law did go into effect on 2015. But I think it's also noteworthy to mention that the Florida Attorney General, he issued a guidance memorandum to Florida law enforcement agencies as well as the prosecuting authorities, such as the state attorney's offices, and notably indicated in there that his office would no longer defend convictions and prosecutions under that particular statute in cases that had similar facts to the McDaniels case. He also recommended that prosecutors and law enforcement that they refrain from arresting and pursuing charges against law-abiding citizens who are openly carrying a firearm. He did note, however, that while that was going to be allowed, that it still did not permit or allow individuals to intimidate or menace members of the public with the firearm, to brandish it in a threatening or violent manner, and also indicated that there were still designated areas that would be considered off limits, in that open carry would not be allowed in those areas. And we will address some of that as well during this presentation. So some specific things to note that the Attorney General's office said, it's that open or concealed carry is still going to be prohibited in certain areas. He specifically referenced Florida Statute 790.0612A. He also mentioned that, of course, private property owners still maintain the right to prohibit any firearms on their premises and to ask people to leave their premises. And I think one of the most important things he noted is that if someone was open carrying a weapon on a private owner's premises, that they had the right to ask them to leave. And if they fail to leave, then they could get a trespass against them, and which is a third-degree felony. So essentially, here's the breakdown over what was allowed prior to September 25th and what has now changed since that McDaniel's ruling. So under the prior open carry ban statute, it was unlawful to openly carry on or about your person any firearm or electric weapon or device. Under that statute, a violation constituted a second-degree misdemeanor, which was punishable by up to 60 days in jail or a fine of up to $500. The McDaniel's decision has effectively legalized open carry in Florida now, and it became final, as I said, on September 25th of 2025. So regardless of that, it is important to note that there are still other firearm restrictions and statutory authority that apply. And some examples I've listed on here. We've got section 790.10, which prohibits displaying a firearm in a rude, careless, angry, or threatening manner unless it is done in self-defense. And that is what the Attorney General's memorandum spoke to, that even though you're allowed to open carry, you cannot brandish it, you cannot wave it around, you cannot do it in any sort of negligent or culpable manner or in a threatening manner. The next statutory authority that's still in place is 790.115, which prohibits the possession of firearms at school-sponsored events, on school property, on school buses, and within 1,000 feet of schools during their hours or doing sanctioned activities, unless otherwise authorized. There are also a couple other statutes that are still in play, and that is 790.15, which of course prohibits anyone from discharging a firearm in public places, on public roadways, or over occupied buildings. Finally, 790.151 is still applicable, and it prevents the use of firearm by someone who is under the influence of alcohol, substances to affect that their normal faculties are affected or impaired. The only exception to that is if you are exercising your right to self-defense or defense of property. As I had mentioned earlier, there are still places where it is illegal for someone to carry a firearm, whether it's concealed or open. Okay, and some of these places, they're listed in that statute I referenced earlier. And here are some of them. Places of nuisance, which includes areas of prostitution, gambling, or criminal gang activities. Obviously, law enforcement facilities, correctional facilities, courthouses, polling places. Government meeting locations where any governing board is holding one of its, special district meeting, commission meetings, county meetings, any of those things, any meetings of the legislature or legislative committee, any areas where schools, colleges, or professional athletic events not related to firearms are being conducted, any elementary or secondary school facility or administration building, career centers are also included in this list. And places where they are licensed to serve alcohol and for consumption on its premises, colleges, universities, passenger terminals, and areas of the airports and state and federal government buildings. Notably absent from this list are public transportation buses. So I know that has come up, that has been a question from some of our other clients. Are we going to have to allow open carry on buses? And unfortunately, at this point, it's not listed in one of these in the statute. Is it something that we hope is changed maybe by the legislature? Remains to be seen, but they are able to open carry on buses currently. See the next one. Andy, can we have the next slide? Perfect. So as a result of this, as I'm sure everyone is not going to be surprised, a fight is actually going to be brewing. It's on the horizon between gun rights advocates and activists. Okay, so now that open carry ban has been declared unconstitutional, it has come to everyone's attention that there are several inconsistencies between the McDaniels decision and some of the legislative authority that's in effect. One example is that the existing firearm statutes, while they prohibit guns in sensitive locations, such as the ones we just went over, there is also a disagreement by the gun activists as to whether that's truly prohibited. And what we've heard is that they're taking the position that no, those sensitive areas are no longer included. And specifically, I'll give you a quote on the next slide from one of the representatives, the general counsel, actually. I can have the next slide. All right, so Eric Friday, who is well known by law enforcement, he is the general counsel for Florida Carry, and he's already stated, quote, "We do not believe that every place currently listed as a prohibited place is constitutionally allowed to be a prohibited place." And he has deemed this inconsistency as a very open question. So we expect that there is going to be people probably trying to test the limits of this and probably attempt to show up at some of those places with firearms and have either law enforcement or the property owner tell them that they are not allowed to carry. So that is very, very much an open question right now. Additionally, following the McDaniels decision, there is what has now been referred to as a potential loophole, the long gun loophole. And what that means is in the existing firearm statutes, it simply talks about handguns, okay? But it does not explicitly mention long guns such as rifles and shotguns. So what does this mean? Essentially, I think what it means is we're probably going to see that people may show up at meetings with long guns, rifles, AR-15s, because technically it is not prohibited in the statute. And so there's going to be several different approaches that I will also discuss later on as to how we've heard some entities plan on handling this long gun loophole. But all of this essentially means that there are lots of unanswered questions, and a lot remains to be seen how it's going to be addressed, particularly by the legislature, who I think are the ones that are going to have to address this because of what the current statutes say and the conflict that has arisen with the McDaniels decision. And essentially right now the legislature is in session, and so there's currently a bill, House Bill 63, which was sponsored by a representative from Parkland, Florida. And what does House Bill 863 attempts to do? Well, basically it wants to remove the distinction between open and concealed, licensed or unlicensed carry, and to keep the current locations, those sensitive locations that I mentioned earlier, to keep them as areas where it is still prohibited to carry any type of firearms. The bill was filed on September 30th, which is just 5 days after this law went into effect. When I looked at this last week, as of October 7th, 2025, it had been referred to the Criminal Justice Subcommittee and the Judiciary Committee. And while the changes aren't extensive, it's essentially basically removing the word concealed and licensed from the statute. We do expect that there is going to be additional legislation to either expand or either further restrict the right to carry guns, and but that remains to be seen. But right now, I think the most pressing matter is addressing whether the statutory framework is going to be revised to include open carry. So, as I alluded to earlier, the primary focus after this new law was passed was what is expected from law enforcement agencies. And in speaking to several different entities, we've learned that there's no easy answer, there's no consistent answer, and various agencies are doing things differently. So I think they're trying to navigate this new landscape. They're trying to determine what can be enforced and how they can enforce it without running afoul of McDaniels, without opening themselves to litigation. And some agencies are taking the approach that, hey, open carry, it's allowed everywhere, even in any of those sensitive locations that I mentioned. We still believe that those areas are prohibited. It has not been specifically overturned. There are other agencies who are taking the approach that no, they are going to arrest anyone who brings any type of weapon into those areas. Additionally, on the next slide, we'll talk about some additional things we've learned from other agencies in terms of the long gun loophole as well.
So Cindy, a question did come up here, and just chiming in because it's relevant to the slide that you're in regarding public libraries. So question was, public libraries have been discussed. Have public libraries been discussed as a sensitive area? We are usually polling places during elections and often have official school visit events, not to mention kids and teens in our building every single day.
I will say that specifically libraries they're not included in that list. So I would say the protections that applies to it is going to depend on the use of the library, right? So if it's being used as a polling place, I think in that instance, yes. If there are going to be kids there, I mean, arguably you can make that. I don't know definitively whether or not that would count, but certainly it would be a good basis. But I think it's something that would have to be looked at and explored further.
Okay, perfect. Thanks.
All right, and with regards to the the long gun loophole, excuse me, I've also been told that some agencies are going to allow people to carry long guns into these sensitive locations, especially and more particularly, my question was, what are your plans for when you're having your board meetings with your commissioners and your district members? And so I've been told, yes, we are going to allow them to bring the long guns because we're not specifically prohibited from that. So some agencies are saying, yes, you can bring it in. Other agencies are saying, nope, zero, no guns, doesn't matter what it is. And yet other agencies have taken a somewhat of a hybrid approach where while they will allow the long guns to be brought into the meetings, they are placing a law enforcement officer in very close proximity to the individual or individuals who are carrying the long guns to monitor them. So again, changing, evolving, ways on how to address that should it happen. So again, unfortunately, no consistent approach by the various entities that we have heard from.
Just a question on this same topic. So this is referring to state and federal buildings, not county buildings?
So in federal, no, this applies to, like, for instance, if your district is having a board meeting at its place of business, we're told that they are either some are allowing the long guns and others are not. Now, in federal buildings, I do believe it's still prohibited. In state buildings, it's only the ones that's on the list, like the courthouses, you know, the law enforcement agencies, correctional facilities. So I think it's a very limited list of where it's prohibited.
Okay.
Okay, so again, that's what I think we can expect from law enforcement agencies. I know there's also a lot of questions in terms of, well, how does this affect employment policies, employment considerations? Because I'm certain a lot of employees have these same questions, and as an employer, you're going to be asked to address that. One thing that's very important to note is that the McDaniels decision, obviously, it was a criminal matter, so it does not address and therefore does not have any effect on an employer's policy regarding the possession of weapons in the workplace. Therefore, any internal policy that the employer has prohibiting employees, public employees, from carrying weapons while on duty should remain in effect. One thing that we have suggested is to consider updating your policy and review your policy language to make sure that it is more general, it includes all weapons, both concealed, open carry, long guns. So if your policy does not specifically prohibit those weapons, then I think you need to consider making updates to those as well. I think it's also going to be important to provide refresher training to your employees concerning workplace violence, your prohibitions on weapons in the workplace, the reason why those policies are in place because of safety. And also you're going to have to provide them training on how to deal with members of the public who are now open carrying guns. And I know that there is a lot of tension because while public employees, because of these policies, are not allowed to have weapons with them in the workplace, members of the public who are interacting with public employees are allowed to do so. And I know that there is that tension, but quite frankly, if you've got workplace policies in effect, there are several reasons why those have been in effect before and will continue to be in effect now. So we've told everyone, and we've seen no one making any change as of yet to their policies to allow employees to also bring weapons into the workplace. However, there is an exception, which I will address in the next slide. So there is something that's referred to as the guns in parking lots law, and that is found in section 790.251 of the Florida statutes. And basically what it is it prohibits employers, including public employers, from banning an employee, a customer, or an invitee from possessing a legally owned firearm when the firearm is lawfully possessed and locked inside or locked to a private motor vehicle in that employer's parking lot. Especially when the employee or the customer is there on the premises for a lawful purpose. So while employees are not allowed to bring the weapons into the workplace, they are allowed to have it securely locked in their vehicle on the employer's premises. Next. So what's also been interesting is I'm sure you've heard of First Amendment auditors, but now with the passage of the McDaniels case, there's now Second Amendment auditors on the horizon. And we've seen some of it in various areas of the state. And who are they? Well, essentially, they're very similar to the First Amendment auditors. They're people who are trying to push the law. They're trying to antagonize law enforcement towards making an arrest, which obviously could lead to costly lawsuits and protracted litigation. They are testing the limits of how this law is going to work. They're showing up at places And they're doing it very carefully. While they're not actually going inside of some of these sensitive locations, they are showing up outside, in close proximity, trying to see and challenge if someone is going to tell them to leave, if there's someone's going to arrest them for being there. And they're loudly proclaiming that they are exercising their Second Amendment rights to open carry in light of this McDaniel's decision. For example, there are already videos of a man walking into a Broward County gas station down in South Florida with a rifle hanging from his hip. There's also another video that has been very much viral online of a man riding a motorcycle down I-95 with a long gun, slung across his back while he's motoring down the highway. And additionally, there's been documented interactions, and these are two pictures of the two incidents that I mentioned down in South Florida. And down in near North Florida, there's been challenges, specifically in encounters with law enforcement. So this particular slide shows someone, an auditor, he's in full body armor, he's got his long gun, he's got his mask on, he's got a cameraman who is filming the entire interaction. And this was in Okaloosa County not too long ago, I think within days of the McDaniel's decision. And I think this particular interaction occurred outside of an aviation school. So as you can see, they're basically in the swale area, standing next to the roadway and to the premises. So they never actually go on the premises. But of course, law enforcement received several calls from concerned members of the public who saw this guy standing on the side of the road as they're driving by. Members of the school, I think at one point, closed their doors because, you see this, you're not sure, what is happening. And we're going to have a link to some of these exchanges, but the videos, I think, if you're interested, I highly encourage you to review them. They're just a little too long for today's purposes, so we're not going to actually view them. And this one in particular, I think, is interesting. They posted it on their YouTube channel and says, "Crazy Karen pulls a gun on me." Well, that same person I showed on the prior slide had an encounter with this lady, and she's pulled on the side of the road. She's in her car, and she's like, "What are you guys doing? What are you doing?" Calling them out, saying like, "This is crazy." And they're like, no, we're just, we're amending, we're just enforcing our rights. We're exercising our Second Amendment rights. And they have this interchange with her. And, they're basically telling her like, "Oh, why don't you believe in the Second Amendment?" Calling her out, so to speak. Well, it turns out this lady does believe in the Second Amendment, and she whips out her gun that she's carrying in her car, and she points it at them, and she's like, "Yeah, I love the Second Amendment. I'm just not doing what you're doing, standing on the side of the street with this gun." So I think that is something that, of course, should be very concerning, right? Because you don't know who has a gun in their car. And if you're out there, trying to say that, you're exercising your rights, that person's going to exercise their rights. And hopefully we're not going to see a situation where, that goes awry, where it ends up into two people exercising their rights with very adverse and fatal consequences. But I encourage you, if you can, take a look at this. I think the interaction is pretty informative, and especially the way that the Okaloosa County sheriffs handled this. They were very calm, they were responsive, they were not combative, very reasonable, and I think candidly these auditors were so disappointed with the way that Okaloosa handled it that they took their show on the road to a neighboring county that I'll share that with you next. So here we see them. They are now walking along the side of a road, again, full body armor. Guy's got an AR-15 and trying to elicit a response from law enforcement again. I think, they were allowed to. No one intercepted them, stopped them, or prevented them from exercising their rights. But I have not seen any of this, personally, but these are just a couple of incidents that we've become aware of. as I mentioned before, they are allowed to tell people not to bring weapons on their property. And they can set their own rules. They can either say, hey, no guns are allowed. They can ask them to leave. They can post signs stating that no guns are allowed on their premises. And again, if someone doesn't follow those directions, potentially be arrested and face trespassing charges. As I'm sure you have heard, Publix, one of the largest grocery stores chains in Florida, they are allowing open carry in all of its stores in Florida. So we don't know if there will be entities that will be following suit, but right now we are aware of Publix. Practical considerations that we think that should be imparted to your employees and to your members. First of all, if you do see someone exercising their right to open carry on your premises, while I think it's important that everyone stay calm. You got to be observant. Just look at their behavior, see what they're doing. Most importantly, do not engage in conversations or confrontations as to why they're carrying the firearm, whether they, have a license or anything like that. Just don't attempt to insert yourself into that situation, to enforce any laws or interpret any laws. Now, if you do notice that there is someone is acting suspiciously, if there are, you perceive it to be that they're carrying the weapon in a threatening manner, if aggressive manner, unsafe, if perhaps they're intoxicated or under the influence of other substances, and you feel that it presents a safety risk to you, then we suggest that you immediately contact 911. You report the behavior. Make sure that you have a good description of the person, that you have, you can also articulate to law enforcement exactly what the behavior is that is causing concern. Law enforcement to arrive on scene. I know that this is probably something that raises a lot of concern, but at this point, I think the best course of action is to just be observant, be very, very calm, don't confront them, and in those very extreme circumstances, make sure that you contact law enforcement for assistance. So some of the key things that I'd like you to keep in mind after today's presentation is that right now, because this is an evolving area, there are no standard procedures in place across the board. As I've mentioned earlier, you've seen that law enforcement agencies are handling things very differently. I think it would be important for you, if you have concerns, to perhaps reach out to your local enforcement authorities to find out what their take is, how they plan to approach open carry at meetings, the long gun loophole, what their position is on that. I think that's going to be very important for you to know how that is going to be handled in your local area. I think more and more seeing people open carrying their guns is going to be much more common. And again, I think the important thing to remember is to not confront them about it. Just keep an eye, be aware of it, and quietly observe what is happening with that person. And again, you can call 911 if you feel that that person is a threat to you, a threat to themselves or others. So while open carry is legal now in Florida, threatening behavior is not and should be reported. And then finally, again, I think there is still a lot that remains to be seen. We don't know if the Supreme Court is ultimately going to weigh in on this, but right now the decision from the first DCA is binding across all courts right now. So that is why it is now the new law in Florida. I think you're going to continue to see auditors test the limits of the law. I think right now they are trying to test the limits of law enforcement agencies. At some point, I would not be surprised if you start seeing it maybe someone trying to test the limits of being able to come into one of your board meetings with either a gun or a long gun. So I think you need to remain vigilant for that, probably have a plan in place as to how you are going to handle that situation should it arise. Again, the legislature is expected to make some decisions in this next session. So we will wait and see what comes of that House Bill 63 as it is currently pending for them. I do believe that is my last slide on this one. But I think so. I think now we can just open it up for questions.
Yeah, so we've got a number of questions, but I think I can summarize some of the questions regarding the open carry on special district property, right? A couple questions were regarding, can a special district basically ban open carry within district property at all times? And the second question that I had was regarding long guns on board meetings. So you mentioned that there are different entities taking different approaches. How would you advise a district into kind of talking this through? Because I imagine you don't want to make that decision at at the time that they show up. What's going to be their policy leading into so they know how to respond when if someone shows up with a long gun.
Yes, and so for the first part of the question, it is open carry is allowed. I would say generally the only place where it is not allowed is when the board is meeting and having its meeting. Okay, but other than that, if they're just coming in on premises to conduct business, they are allowed to have that gun openly carried or holstered on their hip. But but during the board meetings, no, they are not allowed to have that weapon. With regard to the long gun loophole, I think it is very, very important, as you mentioned, Andy, that we need to be proactive in terms of what are we going to do if the situation comes to fruition, instead of having to decide on the spot how to handle it. So I think certainly the board can have a decision. If there's district council, they can certainly reach out to law enforcement, speak with other members to find out what other agencies are doing and how they are handling it. And I think absolutely knowing what the local law enforcement agencies, what their positions are on it, because they may say, we'll come to your meeting, we'll be there, we'll send an officer, but our officer is not authorized to remove someone with a long gun if they attempt to bring it into the meeting. So I do think it's imperative to have that conversation as soon as possible.
So to give the example of a community development district that has their monthly or quarterly board meeting in the amenity center, right? Obviously, the conference room or the space where the meeting's taking place, that's pretty clear, whether or not you can open carry there. But can they enter the building? Can enter the district? Like, what's the I guess what's the border? At what point are you entering the public meeting, right?
Right. And I think that's a great question. I think to err on the side, I think really it just says the location where they're having the meeting, right? So that has not really been defined. So unfortunately, I don't think there's a clear-cut answer on that. I think if you say the place where the meeting is actually being held, if you say no, you cannot come in with there, I think that's a much stronger argument. I think there's also an argument that I say, well, this is the location, which includes, the entire premises where the meeting is being held. That's a little, I think that's less clear, right? I think you can make the argument, but on the other side, they can say, well, but that's not where your members are actually meeting. They're in a separate facility. So why can't I, if there's some other purpose that I can accomplish other than being in this meeting, why am I not allowed to open carry my gun in that area? So I think that's a little trickier.
Okay. The question regarding a polling place, I think going back to the conversation we had about libraries. So is this year-round or only on days of the election, only on election days?
I believe it's only going to be, if you're not like the supervisor of elections office, I think anything else that's designated as a polling place. I think it's only going to be when you're actually on election day, when you're actually acting as a polling location.
Question about, sorry. And by the way, just a quick, we will be sending a follow-up email to everyone that attended the webinar. Is going to have a link to the video that Cindy referenced. Also, is going to have a link to the recording of this webinar as well. So expect that within 24 to 48 hours, just in case. I know somebody was having some technical issues and was not able to capture everything that Cindy was saying, right? Question about public housing authorities. Is there current language for employees and residents? It can be that can be amended to restrict open carry.
I don't believe so. Other than the places where they're having their meetings. Unfortunately, I think, anywhere else is open game. And right now, the only limitation is if you qualify for one of those places listed that we mentioned above.
Okay. Question regarding the potential ramifications under Florida Statute 790.33, Section 3, for a special district that does not allow long guns in board meetings. And sorry if I put you on the spot on that statute. I should have pulled it up first and read the statute. So
yeah.
Yeah, so I can pull that one up.
Yeah, we can take a look at that one. If that does have a specific prohibition, that has not been declared unconstitutional, right? And that's still effective. So I'd have to take a look at the exact verbiage of it. But I would say if long guns are specifically prohibited pursuant to that statute, then yes, that would be grounds to rely upon that for not allowing it on premises.
Another question that kind of follows what we were talking about on special districts, particularly CDDs. What about amenities such as pools and gyms?
Unfortunately, that's not one of the areas that's deemed sensitive.
Okay. Question regarding can a special district prohibit employees from possessing firearms on district property and or in the facility? Does the statute trump district policy?
The statute does not trump district policy, or the McDaniels does not trump it, because first of all, there are statutes that say that you are allowed to. The only one that's really applicable is the one I mentioned about the guns in the parking lots law. So no, you're not allowed to bring the employees are not allowed to bring it into the district's facilities, but they can keep the gun if it's securely locked to or in their vehicle in the employer's parking lot.
Okay. I think that eventually the question is going to come up that there might be some entities, some districts that would want to explore the possibility of allowing employees to open carry. Can you kind of talk a little bit about the potential issues and exposures that would?
Yeah, really and truly, it's from a workplace safety position. I think that's really how it needs to be looked at in terms of. I understand the reasons why employees may feel like, well, if members of the public are allowed to open carry their guns, why can't we? But I think employers have to make that decision and weigh the risks of allowing their employees to have weapons at work, and how that aligns with their goals for safety, their overall safety of all employees, and what the end game is in terms of that. So I mean, I think there's a lot of considerations that will need to go into effect and before making any of those changes.
A couple of questions regarding like alcohol. Let's say an example would be a community development district that has a pool where there might be a bar serving alcohol, right? You're not allowed to carry in bars. So how would that apply to like a pool setting or an amenity center that has a restaurant that serves alcohol as well?
Right. So I think if it's if it's an entity that routinely, that's what they do. They sell alcohol for consumption on the premises. such as a bar or a restaurant located on the district's premises, I think that would qualify as one of those places where it's prohibited.
Okay. So one way of potential solution is just build more bars. Just kidding. We have a question here. We have some testing to the right to hunt on CDD property. How does that interact with open carry and the hunting fishing regulations?
I candidly don't know the answer to that. I don't believe there has been any, changes to that. So I think whatever is currently in place, you probably need to follow that. But I don't actually know the answer to that candidly right now.
Okay. There was another comment regarding the Florida statute 790.33, and I think it's something that we will look into. We'll address in the follow-up email. This was Vivek brought it up. I think it's a good point and something that we need to address when we send a follow-up email as well. Right.
Yeah.
Another question regarding a district owns and operates a golf course. Is open carry allowed?
I mean, on the golf course, I think it is. If there is a restaurant or bar serving alcohol inside those facilities, no.
Okay. And a lot of these, not just golf courses, sometimes even amenity centers, they're operated by a private operator, right? So it's technically district property, but operated by a private vendor. Can a private vendor restrict open carry?
No, that's a very interesting question because it's a hybrid, right? And we know that private business owners can restrict it and post signs, but because it is on the government, on public property owned by the district, does that change something? I don't know the answer to that either. I think that's probably something that, we'd have to also look into.
Okay. Another kind of gray area is regarding professional sporting events, right? What about amateur sporting events or youth or adult sports on district fields? Sometimes you have leagues that have, I wouldn't call them professional, but they have, formal tournaments, invite teams from across the country to play on their fields. Would that be considered a professional sporting event?
I don't know that it's considered a professional sporting event. And so I think these questions are really showing the fact that there are so many unanswered questions that will need to be addressed. But I don't believe they're considered professionals, so technically would not fall on that list. Now, if it's a league group, but it's not associated with a school, it may not be. But I can't tell you definitively, yes or no.
Okay. Another question is, sometimes districts will rent out a private clubhouse or, an office space to have a meeting. Obviously, the building is private, but it's being used for a public meeting. Can the district follow the landlord or the property owner's policy?
Right, because you're just having a meeting. That's probably one where that is possible, especially if prior to you having your meeting there, it's been pretty well established that the private owner has signs posted or a policy that no weapons whatsoever are allowed on its premises.
Okay, perfect. So we had so apologize. So we're getting questions on both the chat and the Q&A. So I'm going back and forth trying to get to most of these. Let's see here. There are a couple of questions regarding whether a gun, the holstering of a weapon, right? Whether it made a difference or not, whether that weapon was holstered or not. Would still be considered. Yeah.
I do believe the weapons are still going to be required to be holstered and properly secured on the person. Okay. But it can be visible. But I think it's still going to be needs to be properly holstered and secured. Yes, if they're, I'm sorry, I just saw this question pop up. If they are waving it around, that is considered brandishing. So that is not allowed.
Okay. So I think we've covered about most of the topics in the Q&A. Cindy, I appreciate you. I know that we're peppering you with questions on a very new issue. So I really appreciate you answering these questions. Again, we'll be sending out a follow-up email to everyone that attended. We'll have some additional resources and information there and clarifications on some of the questions that came up. Appreciate you guys for joining the webinar today. Cindy, again, thanks again for your partnership throughout all these years and for all the guidance that you provided, not just myself and my team, as well as our membership. Okay.
Thank you. Thank you, guys.
I guess appreciate it. Thank you.
Okay. All righty. Bye, everyone.